Hello, and welcome to a presentation on religion and creed discrimination by the Montana Human Rights Bureau. In order to understand religion and creed discrimination specifically, you must first understand what discrimination is generally. So, what is unlawful discrimination? Unlawful discrimination can be simply defined as an adverse action taken in a protected area against an individual because of his or her protected class status. To help us better understand the definition of discrimination, we're going to break down and define some of its terms. This slide shows a list of the protected areas under discrimination laws that the Bureau enforces. Protected areas include employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes. But note that Montana law recognizes the additional protected classes of creed, marital and familial status, political belief, and vaccination status, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Religion is a protected class under federal and state laws. The federal law that prohibits religious discrimination in the area of employment is Title VII of the Civil Rights Act of 1964. Montana's Governmental Code of Fair Practices and the Montana Human Rights Act are the state laws that prohibit religious and creed discrimination in the various protected areas seen here. Title VII of the Civil Rights Act of 1964 defines religion as including all aspects of religious observance and practice, as well as belief. These protections apply whether the religious beliefs or practices in question are common or non-traditional, and regardless of whether they are recognized by any organized religion. The test under Title VII's definition of religion is whether the beliefs are, in the individual's own scheme of things, religious. Belief in God or gods is not necessary either. Non-theistic beliefs can also be religious as long as they occupy in the life of that individual a place parallel to that filled by God in traditionally religious persons. The protected class of religion also applies to individuals who are perceived to be of a certain religion or who do not possess religious beliefs or engage in religious practices at all. EEOC guidance provides examples of religious observances and practices. They include attending worship services, praying, wearing religious garb or symbols, displaying religious objects, adhering to certain dietary rules, proselytizing or other forms of religious expression, and refraining from certain activities. The motivation behind one's observances or practices are key when determining whether they are religious in nature. For example, someone can be motivated to follow certain dietary restrictions for purely non-religious reasons. As mentioned before, creed is a protected class only under Montana law. There are no protections for creed under federal law. The Montana Human Rights Act does not define creed, and the Montana Supreme Court has not addressed the issue either. However, the legislative history of the Montana Human Rights Act suggests that creed is meant to encompass deeply held beliefs, much broader than religion. In the 2011 McCoy case, the Office of Administrative Hearings examined how to define creed and determined that creed should not include every statement of opinion or belief, nor should it include opinions which may be changed by reasoned argument. Furthermore, despite the legislative history noting an intention to make the protected class of creed broader than religious beliefs, the Office of Administrative Hearings followed other states' case law in deciding that creed was tantamount to religious belief. Historically, the Bureau has provided positions on vaccines, white supremacy, and vegetarianism as examples that fall under the protected class of creed. However, what exactly creed means under the Montana Human Rights Act is subject to future judicial review. So now that you have an understanding of what is included under the protected classes of religion and creed, we will next look at the types of discrimination cases, including these protected classes that we see here at the Bureau. Whether or not someone is a member of the protected class of religion or creed is a threshold issue, the first element, but not the only element, that must be satisfied when determining if discrimination occurred. Discrimination based on religion or creed can take several different forms, including disparate treatment, harassment, by association, print or circulation, and in an indirect way, retaliation, when someone opposes religion or creed discrimination. Individuals are also entitled to requests for an accommodation of religious expression, belief, or practice. We will now review each type of discrimination as it relates to the protected classes of religion and creed. Disparate treatment cases allege that a respondent treated a charging party differently than others based on his or her protected class. The first step of a disparate treatment case is the prima facie case. Prima facie is a Latin term that means on its first appearance. The charging party must prove each element of a prima facie case to show that what the respondent did, the adverse act, looks like discrimination on its first appearance. The first element requires the charging party prove that he or she falls under the protected class of either religion or creed. Next, the charging party must show that he or she was subjected to some type of bad act by the respondent. And lastly, the charging party must prove that there is a connection between his or her membership in the protected class and the act taken by the respondent. Some evidence that raises a reasonable inference include that the adverse act does not happen to those who are not of the same religion or creed, or comments that suggest the protected class was a factor in the discriminatory act. When analyzing disparate treatment cases, a shifting burden analysis is used. As we just covered in the first step of analysis, a charging party has the burden of proving the elements of a prima facie case. After the charging party meets that burden, the burden then shifts to the respondent to produce a legitimate, non-discriminatory reason for the adverse act it took against the charging party. Once the respondent produces that legitimate, non-discriminatory reason, the burden then shifts back to the charging party to prove that the reason proffered by the respondent is pretext or unworthy of belief. In order to prevail on a disparate treatment complaint, a charging party must prove his or her case by a preponderance of the evidence. This means that discrimination more likely than not occurred. This standard is less onerous than beyond a reasonable doubt or based on clear and convincing evidence. Rather, it is a 51% probability based on the evidence at hand that discrimination occurred. It is important to note that the administrative rules of Montana change this analysis a bit in the event that there is direct evidence of discrimination. When there's direct evidence, there is no shifting burden, but rather the respondent must prove by a preponderance of the evidence that an unlawful motive played no role in the action it took against charging party. In the alternative, the respondent can prove that the direct evidence is not credible and unworthy of belief. An example of direct evidence would be a text message from a hiring manager to an applicant that they hired the successful candidate because he attends the same church or mosque as the company's owner. We will now walk through a case example so you can see the shifting burden in action. A charging party filed a religious disparate treatment case with the Bureau on behalf of his minor child against the child's high school. Charging party asserted that his daughter's high school counselor encouraged her to break her religious fast during Ramadan, a religious observance of the Islamic faith, by providing junk food and telling the daughter that fasting is unhealthy. Walking through the elements of the prima facie case, charging party's daughter is an adherent of the Islamic faith and therefore a member of the protected class of religion, satisfying the first element. Charging party asserted that his daughter's high school counselor gave his daughter junk food during Ramadan and encouraged her to break her fast, satisfying the second element. Lastly, charging party asserted that he had complained to the high school for several years about his daughter being provided junk food and that he had specifically asked the counselor not to give her food during Ramadan. Accordingly, charging party satisfies the third and final element of the prima facie case. When the burden shifted to respondent, it stated that it was unaware when the daughter observed Ramadan and it did not encourage her to break a religious observance. Then it was up to charging party to show respondent's reasons were not worthy of belief. First, evidence showed that the charging party had contacted various school officials over the years complaining that his daughter was being given junk food while at school, which he disapproved of because his family only eats organic whole foods. Conversations around this topic seemed to focus on the daughter's weight, not religion or fasting. The counselor at issue stated she was unaware of the daughter's religious fasting and only gave her crackers a few times after the daughter told her she was unwell because of how long she had gone without eating. The daughter's school email account showed that she also asked friends to bring her snacks from their homes to give to her during school. Ultimately, charging party was unable to show that even if the counselor provided the daughter food during Ramadan, that she did so in order to purposefully interfere with the student's religious practices. Harassing someone or creating a hostile work environment for someone based on any protected class is unlawful, including religion or creed. The legal framework for a harassment complaint can vary based on what protected area the discrimination occurred in. As you can see here, the elements are different for harassment or a hostile work environment complaint that occurs in the area of employment versus harassment that happens in the area of public accommodation. As it relates to the protected classes of religion and creed, generally speaking, a charging party must show that he or she is a member of one of those protected classes who was subjected to either offensive or hostile conduct because of their membership in the protected class. Many times, the conduct comes in the form of comments or unwanted touching. After the charging party establishes that, the remainder of the elements left to prove depends on what protected area the discriminatory acts occurred in. Regarding the last element in the area of employment, how this is applied depends on who was engaged in the harassing behavior. For example, if the harassment is being carried out by a president or owner, the business respondent is always liable. However, if the harassment is carried out by a coworker or non-employee, the business respondent is only liable if it knew or had reason to know about the harassment and did not take prompt, corrective action to stop the harassment. Like quid pro quo sexual harassment, religious coercion in which an employee is pressured to abandon, alter, or adopt a religious practice as a condition of employment can also be unlawful harassment. It's interesting to note that someone can also file a discrimination complaint for disparate treatment or harassment if they're treated differently because of their association with a person who is a member of the protected class of religion or creed. This type of complaint is called a by association complaint. An example would be a Jewish deli refusing service to a Jewish woman because it disapproves of her dating a Catholic. The deli is engaged in religious discrimination against the woman because of her association with the non-Jewish man. The state of Montana also prohibits any printed materials, advertisements, or applications used by employers from either stating or implying that religion or creed, or any other protected class for that matter, is being limited or discriminated against in some fashion. For example, if an employer has an online application that asks as a preliminary screening question whether or not the applicant is an adherent to a certain religion, and rejects an applicant that answers yes, that would be an application that expresses a limitation based on religion. The statute states the only time employers are allowed to make such statements in print or applications is when there is a bona fide occupational qualification, or BFOQ, meaning that the restriction based on religion or creed is reasonably necessary to the normal operation of business. But be aware, the laws that regulate whether or not a BFOQ exists make it a very high bar to prove the existence of a BFOQ. Under most circumstances, an employer will find it very difficult to establish it is entitled to such a defense. Retaliation is the second highest number of filings received by the Bureau each year. It's important to note that retaliation is its own creature, so to speak, rather than a subcategory of religious or creed discrimination. It's a bit indirectly related to religious or creed discrimination because, unlike most other forms of discrimination, the person being retaliated against doesn't have to be a member of a protected class or associated with a member of a protected class. Here you see the three elements that constitute a prima facie case of retaliation. Retaliation is when a respondent takes a significant adverse act against a person because he or she engaged in protected activity. Protected activities include opposing or objecting to discriminatory acts, participating in an investigation or case of discrimination, and requesting an accommodation. For example, if an employee complains to their boss that coworkers are mocking an employee who wears a turban because he's Sikh, which is a religion originating in India, the employee has opposed religious discrimination and engaged in a protected activity. Likewise, if the employee acts as a witness in the employer's investigation into the religious discrimination of the coworker, the employee has engaged in a protected activity. Asking for a religious accommodation from an employer is protected activity as well. So, for example, if a restaurant server is Seventh-day Adventist and asks to not be scheduled to work on Saturdays so that he can observe his religion's Sabbath day, he has engaged in protected activity. When determining whether or not the charging party was subjected to an adverse act, the question revolves around whether the act may dissuade a reasonable person from engaging in protected activity again. Continuing on with the example just discussed, if the employer gives the employee who reported harassment of his Sikh coworker and participated in the investigation into the harassment allegation a poor performance review or demotes him because the employee engaged in a protected activity, the employer has retaliated against the employee. It's reasonable to think that a demotion or bad evaluation could dissuade the employee from speaking against discrimination again. Title VII of the Civil Rights Act of 1964 requires that employers provide religious accommodations, or modifications to policies for religious purposes, to employees based on their sincerely held religious beliefs or practices. The Bureau uses federal law as guidance in evaluating religious accommodation requests under other protected areas such as public accommodations, education, and housing. The protected class of creed, however, is not entitled to an accommodation. Here you see the typical analysis used by the Bureau when considering cases asserting a failure to provide religious accommodation. First, the charging party has a sincerely held religious belief that conflicts with respondent's policy. Next, charging party informed respondent of the conflict and need for an accommodation. And finally, respondent failed to provide a reasonable accommodation. While factors may be considered to determine whether a belief is sincerely held, such as evidence of acting inconsistently with the proposed belief or the religious accommodation request following the denial of a similar request for secular reasons, it is generally presumed or easily established that a stated religious belief is sincere. One reason for the presumption is that beliefs or degrees of adherence to religious beliefs can change over time while still being sincere. EEOC guidance suggests that the broad definition of the protected class of religion means an employer should ordinarily assume that an employee's request for religious accommodation is based on a sincerely held religious belief. A duty to accommodate will usually entail making a special exception from or adjustment to the particular requirement that creates a conflict so that the individual can observe or practice his or her religion. Accommodation requests often relate to work schedules, dress or grooming, or religious expression or practice. Like under the ADA, an entity does not have to provide the requested accommodation so long as the accommodation provided is effective. For example, an employee who requested to work Saturdays instead of Sundays to observe a religious Sabbath and instead was offered Sundays off for working on Thursdays is not in violation of the law for failing to provide the employee's preferred workday, since the employer is providing the Sabbath day off accommodation. Religious expression or practice can take many forms. It may be the display of religious icons or messages at workstations, the use of particular religious phrases when greeting others, or it can be proselytizing through discussion or distribution of literature. Individuals may request accommodations for various religious expressions or practices, or a respondent may not even know about the religious expression that is occurring until others complain. These types of scenarios demand a careful balance of religious accommodation rights and the right to be free from religious harassment. Relevant considerations can include the disruption to business operations, coworkers, or customers if the religious expression continues. Conduct that is disruptive can constitute an undue hardship, even if it does not rise to the level of unlawful harassment. And since an employer has a duty to protect employees from unlawful harassment, it would be an undue hardship to accommodate expression that is harassing. To determine if religious expression is harassing, an employer will want to analyze the conduct under harassment, such as whether the conduct was offensive, unwelcome, and pervasive. Remember, mere subjective offense or disagreement with unpopular religious views or practices is not sufficient to rise to the level of unlawful harassment. To the extent possible and based on the circumstances and situation at hand, engaging in a good faith process similar to the interactive process under the ADA can be helpful in evaluating a religious accommodation request. The Administrative Rules of Montana call this a mutual obligation to engage in bilateral cooperation in search for reasonable resolution of conflicts which arise between an employer's business and an employee's religion. Regarding this process, in the context of employment, EEOC guidance further explains if the employer reasonably needs more information, the employer and the applicant or employee should discuss the request. The applicant or employee may need to explain the religious nature of the belief, observance, or practice at issue, and cannot assume that the employer will already know or understand it. Similarly, the employer should not assume that a request is invalid simply because it's based on religious beliefs or practices with which the employer is unfamiliar. But the employer should ask the applicant or employee to explain the religious nature of the practice and the way in which it conflicts with a work requirement. In determining if a conflict exists, it's irrelevant that the employer does not view the work requirement as implicating a religious belief, or that most people of the applicant's or employee's faith would not. It is the applicant's or the employee's own religious beliefs that are relevant. As mentioned, engaging with the individual requesting the accommodation is best practice in every protected area, not just employment. For example, the information a restaurant could glean from engaging with a customer requesting a religious accommodation, such as a dietary accommodation, may be the information that will help it prove providing the accommodation would pose an undue hardship. If you don't engage and understand the request, you may have a hard time proving in a discrimination case that the proposed accommodation would actually pose an undue hardship. An entity faced with a religious accommodation request should reasonably seek information about the request to make an informed and reasoned decision. When an individual seeks a modification to an entity's policy based on religious observance, practice, or belief, the entity is required to provide a religious accommodation unless doing so creates an undue hardship. An undue hardship is determined on a case-by-case basis. Title VII of the Civil Rights Act expressly states that an undue hardship is a defense to the provision of a religious accommodation. For those of you familiar with the term under other federal laws, you understand that undue hardship is defined as a significant difficulty or expense. However, despite the plain language in Title VII, the U.S. Supreme Court has held undue hardship under this statute to mean a de minimis cost or burden, which is a much lower standard. The Administrative Rules of Montana state that an employer has a duty to accommodate an employee's religion unless to do so would cause a more than de minimis hardship on the conduct of business. The rule goes on to explain that some forms of de minimis hardship include a significant cost to the business or a violation of a contractual obligation that cannot be reconciled. Meanwhile, EEOC cases suggest that it looks for the higher standard in its cases when looking at denials of religious accommodation requests. Therefore, based on recent trends and uncertainties, it is best practice to use the significant difficulty or expense standard of undue hardship when evaluating whether or not a religious accommodation can be provided. In certain circumstances, a partial accommodation can suffice as well. For example, if an employee cannot work Friday night or Saturday shifts due to a religious Sabbath observance, but providing that accommodation each week poses an undue hardship, the employer must provide the accommodation partially, to the extent that it can without suffering an undue hardship, which could include granting some but not all Friday evenings and/or Saturdays off. As another example, a Native American male applies for a job as a server at a restaurant that requires its male employees to wear their hair short and neat in order to provide a certain image to its customers. When the manager offers him the job, he is informed he must cut his hair. The Native American explains he keeps his hair long based on his religious beliefs and offers to wear his hair clipped up or under a hairnet. However, the manager refuses this accommodation and denies him the position if he will not cut his hair. Since the evidence suggests the applicant would have been accommodated without undue hardship by wearing his hair up, the employer will be liable for denial of reasonable accommodation and failure to hire. Title VII of the Civil Rights Act provides a couple of exceptions to its prohibition against religious discrimination. One of those exceptions is for religious organizations whose purpose and character are primarily religious. This would include churches, houses of worship, religious schools, and hospitals and charities with a religious character and purpose. These types of institutions are allowed to consider religious affiliation or beliefs of applicants or employees when hiring or making employment decisions. This exemption applies to employees who work for the religious organization in roles that are not specifically religious, too. Religious organizations can create and maintain communities composed solely of individuals faithful to their doctrinal practices, whether or not every individual plays a direct role in the organization's religious activities. An example of the religious organization exemption is a Catholic college who terminated a professor after she signed a pro-choice advertisement in the local newspaper, a position that violated church doctrine. Another exception to religious discrimination is what's known as the ministerial exception. This exception is based on First Amendment safeguards providing religious organizations freedom from interference from civil authorities to select those who will personify its beliefs, shape its own faith and mission, or minister to the faithful. The Establishment Clause of the First Amendment prevents the government from appointing ministers. The Free Exercise Clause of the First Amendment prevents the government from interfering with the freedom of religious groups to select their own ministers. Unlike the statutory religious exemption discussed previously, the ministerial exception applies regardless of whether the challenged employment decision was for religious reasons. For example, a past disability discrimination case was barred because the teacher who was fired after taking disability leave under the ADA was deemed to fall under the ministerial exception. While the court would not provide a rigid formula or checklist of factors in its cases to determine when to apply the ministerial exception, it noted that an employee who performs a vital role in carrying out a religious mission for its employer would trigger this exception. This means lower courts will be left to figure out how to apply the exception, which may result in divergent applications. You should now have a basic understanding of discrimination laws regarding the protected classes of religion and creed. Additional, more in-depth trainings on topics covered in this training, such as harassment and retaliation, can be found in other training videos offered on the Montana Human Rights Bureau's YouTube channel. For more information about discrimination or the Bureau, please visit our website at www.montanadiscrimination.com or give us a call toll-free at 1-800-542-0807 or locally at 406-444-2884.